Everyone. Good morning, everyone. Thank you for having us. My name is Jordan Kotler. I'm a housing attorney in the Denver County Court Clinic Supervisor at CPLP. And with me today is my colleague Becca, who is also a housing attorney. And we're going to be presenting on 2025 landlord-tenant legislative updates. So thank you for joining us. Some of you may be familiar with our organization from some presentations we've done in the past, but for those of you who have not worked with us before, we strive to prevent homelessness through legal representation, housing navigation, education, and advocacy, and believe that no one should become homeless for lack of access to housing justice. To learn more about the work that we do, there's a link to our website here. And then before we get started, just our disclaimer that this presentation, it provides general legal information about Colorado housing law as of today. It is not legal advice specific to any situation or case. If you or someone you know has a legal claim or issue or a fact-specific question, we do recommend that they fill out an intake form with us or contact an attorney to learn more about their individual rights. This says hold questions to the end. Please ignore that. Becca and I would like to welcome you guys to ask questions in the Q&A throughout the presentation so we can have more of a dialogue. If you do have questions about a specific situation, we might not be able to answer them to the extent that you're able to put them as a hypothetical. We may be more inclined to answer them, but if you could just keep those questions more broad, that would be helpful for everyone. And so this is not a complete summary of the legislative session from this past year. It's just focused on housing related legislation. And there may be information or rights that pertain to residents of mobile home parks or residents of federally subsidized housing that we might not cover here today. Okay. And
to the overview, just because we have a lot of participants signing in, and we do want to keep this interactive and understand who is in the room. If you could put in the chat just your name and your role, and if there are specific themes that are relevant to what we're going to be talking about today that you focus on or are curious about, that will help us get a sense of who we're talking to. So you can go ahead and put that in the chat to everyone. Great. Thanks for kicking that off. We'll be keeping an eye on that. Oh, excellent. Lots of folks from organizations we partner with and are familiar with. Welcome all. Some housing specialists, some rental assistance folks. There will definitely be some of these updates that are relevant to the work that you all do. Voucher supervisors along the same lines. All right, and I see that there will be some questions or interest in the junk fees bill that we'll get to, which is on our agenda here.
Thanks, Becca, for kicking us off with that. Great to see. I see some folks that I have emailed with, so it's great to see some familiar names. So here is an overview of the housing legislation that passed this year. So we'll go into, a little more detail on each of these bills. But there were increased protections for victim survivors of domestic violence, domestic abuse, unwanted sexual behavior, and stalking. additional protections for tenants with housing subsidies, uh, uh, changes to the residential tenant screening requirements for tenants who are applying for prospective housing, um, protections against deceptive pricing practices, which is colloquially referred to as the junk fees bill, security deposit protections, specific prohibitions in rental agreements due to death, and enforcement of the landlord-tenant law by the state attorney general's office, and then as a budget item, the funding of the eviction legal defense fund.
We'll also be talking about some of the ones that were either introduced and did not make it through the legislature, and one bill that the governor vetoed. And those will be about jury trials, about another bill that regarding rent increases by the landlord, and what would be reasonable, one that would have repealed some other bills, and one that is related to algorithmic price fixing. And again, don't get too distracted by these because they are not, in fact, the law. But we want to go over sort of what the legislature did and was thinking about, because it's good context for the laws that do exist and what might continue to change in future legislative sessions. Okay, so um, one of the bills that CPLP worked very closely with the legislative representatives on is this HB 251168, Housing Protections for Victim Survivors. And I'll just make a note about the language. We do say victim survivors when it comes to people who've experienced this kind of harm. Some people do identify as a victim, some people identify as survivors, and we don't like to put labels on people's experiences. We want to empower people to identify as they choose with regard to how they've experienced those things. And um, for people who've experienced those things, including unlawful sexual behavior, stalking, domestic violence, domestic abuse, as Jordan was saying. And there are specific definitions of those things that are outlined in the bill. Um, they have a few more remedies available in the eviction process, in the lease breaking process. So basically, it is expanded defenses available when it comes to um, eviction. It broadens the type of documentation that a victim survivor could use in order to demonstrate to a landlord and the other players that need to know that they have experienced this type of violence. Um, and also for victim survivors who are unable to pay their rent, and that where that inability to pay rent is related to what they've experienced, they have an opportunity for a payment plan with some restrictions, that has some criteria that a landlord needs to offer to give them a little bit more time to catch up. Um, and so it also uh, requires that the service of the summons be through personal service. It extends the time for that writ of restitution, which is a document that the court provides that gives the sheriff the ability to do a physical eviction. So if somebody has asserted defenses related to this, they have more time post-judgment to finish moving out, to avoid the sheriff doing it for them. With regard to the lease break process, it aligned some of the language in the different parts of the law and creates some teeth in the law for remedies that tenants can seek if landlords are not honoring their rights under that process. It also provided more flexibility in the court procedures and clarified some protections around safety uh, and what a landlord should do with a security deposit. And this section does continue on to the next slide too. Um, Part of it went into effect right away when it was passed in May, and some other pieces went into effect in August. Now, this entire bill is in effect and has been since August 6th. So, both the demand and the summons have new language requirements that have to give victim survivors more information about the rights and remedies that they have available. The summons, and that's again the document that tells a tenant they need to come to court for an eviction case specifically. It also needs to provide tenants information about how they might register for the address confidentiality program, which is a program that helps victim survivors keep their information confidential, and gives them an alternate address that they can use. And I'm certain that some of you help to administer that program and have worked with clients who are involved in that. Um, Also, since August 6th, the landlord has had to disclose um, that the defendant is a victim survivor to the court with the victim survivor's consent to do that. So if the victim survivor raises it in an answer, that then the court is aware, but they need to, if they are aware of that information, they need to share that information again with that person's consent. And so if somebody has a past eviction judgment from any time, uh, and that judgment showing up on a eviction record or tenant screening report is making it less safe for that person, related again to their experience as a victim survivor. Victim survivors now have an option to file a motion with the court asking for that case to be suppressed. And the language in this bill is pretty strong, that a court shall do that if the victim survivor has demonstrated that that is a need. So we advocated for this bill. We feel strongly that these are protections that will help people who've experienced these things. Victim survivors are often some of our most vulnerable clients for lots of reasons, and I can say for myself, it has been very rewarding in recent months to be able to offer them some extra tools in the eviction defense process, particularly.
Thanks.
Um,
Thanks,
yeah,
Mika.
so do we want to pause and see if there are any questions specific to 1168?
I'm just going to add a clarifier that most of these, oh, it's not letting me go back. Let's see. Where's my presentation mode? I'm gonna have to go back for a second. Okay, so most of these protections kick in once the tenant has provided specific documentation to the landlord of their experience with one of these types of abuse. So that documentation includes either a protection order, a police report, a letter from a third party, which some of you may be very familiar with. And now the new documentation that they're allowed to provide is a self-attestation. Um, so the tenant would need to provide that one of those forms of documentation to assert their right to a payment plan, to for the summons to have to be served through personal service, through to be entitled to the 30-day writ of restitution, to be entitled to the lease break procedures, and then to be entitled to the service of the demand, the 3 attempts at personal service of the demand. The demand and summons does have to have that language for everybody. The demand specifically only in non-payment of rent cases. So it's a little bit confusing. There are some things that apply to everybody, but for the most part, if you're working with the victim survivor and they want to exercise any of their new rights under this law, we'd probably, to the extent it's safe to do so, encourage them to provide one of those forms of documentation to their landlord as soon as possible, because if they are behind on their rent and they do ask for a payment plan and provide that documentation, the landlord's required to offer one within 3 business days. So that's just some added clarity on when some of these go and kick in. So I'll pause for questions now.
Yeah, and Jordan and I are both a little bit in the weeds on this bill particularly. So if we use some jargon, or if there's anything that was confusing in what we said, please write your questions in the Q&A. We want to make sure um, that you understand. Okay, we did get a question, which I think we can answer. Does this include payment plans around utilities due to the landlord? Utilities due to the landlord got other fees and or damages. Um, so yes, I do believe there's language that says it's the full balance owed. Um, that might it might get interesting how that could intersect with another bill we'll talk about later, that junk fees bill. But I do believe um, that it's within a victim survivor's right to include in that payment plan, which should be that. So I should say the limits on that payment plan are that it has to be within 9 months, and it has to be at least $25 a month that that victim survivor is paying to their landlord. So I have seen payment plans already that do include other fees and utilities looped into that. And to the extent that a tenant is disputing that they actually owe those fees, that might get a little more complicated. But I would say yes, that is an option. Jordan, do you agree with that?
Yeah, I'd say generally it's best practice to the extent there are additional and any amount owed. I think it's in both parties' best interest to include that in the payment plan.
All right. If there are any other questions about 1168, we can hear those now. Otherwise, we can move on to the next section.
Great. So uh, now I'm going to talk about House Bill 1240, which was protections for tenants with housing subsidies. So many of you may be familiar with the Federal CARES Act that came out of the pandemic. And part of that had a requirement that landlords that either live or have a property that has a federally backed mortgage or otherwise participate in a federally subsidized housing program are required to provide 30-day notice before an eviction. regardless of what the state law required, right? And so in Colorado, the standard is the 10 days for non-payment. This expanded it to 30 for tenants living in covered properties. What this bill did was it codified that federal law into state law. Because there was a lot of uncertainty about what might happen to that new law at the beginning of this year with the new administration and the new Congress. So that is now sort of we've got extra coverage there. It also defines source of income discrimination to include a landlord's failure to reasonably cooperate with rental assistance applications. Um, it expanded relief to tenants in subsidized housing whose landlord have violated the warranty of habitability. Basically, it just clarified that if if a landlord breaches the warranty of habitability, a tenant in general, may be entitled to compensation for the reduced rental value of the property during the time that they lived in the uninhabitable conditions. And what it clarified is that a landlord, if the tenant only pays a portion of their rent and gets a subsidy for the rest of their rent, they are still entitled to the financial compensation for the full reduction in the rental value of the property as a way to ensure that landlords are meeting their obligations under that warranty of habitability and not, taking advantage of tenants just because they might be paying less of their rent. It also creates a minimum penalty of $5,000 for source of income discrimination based on the tenant having a housing subsidy. And this went into effect in May of this year. Any questions about that? I saw one popped up in the chat and I think Becca answered it. You want to say it out loud for those who didn't
Sure. So
catch
somebody
that?
asked if federally subsidized properties here includes LIHTC, which for those of you who don't know, that's low income housing tax credit units. And certainly for the CARES Act portion of this slide, that absolutely yes, that pertains to that. With regard to the protections for tenants with subsidies whose landlords have violated the warranty of habitability, I think somebody in a LIHTC property would have already been covered by those remedies. So that the change this year was really for people who have a voucher and who aren't going to be paying that full amount themselves. So that didn't really change for LIHTC units. And there are some places in Colorado law that differentiate, what a subsidy is or what sources of income discrimination covers. So I want to be a little bit nuanced in that, like, as it pertains to the CARES Act, yes, LIHTC is definitely part of that. If there are follow-up questions, I'm happy to field those too.
Becca is our CARES Act guru. So if you have CARES Act questions, so now's the time. Okay, excellent. Well, with that, of course, we can always come back. But Becca, if you want to talk about residential tenant screening.
Sure thing. So a couple years ago, there was a law that introduced these portable tenant screening reports. And so this is not new this year, but this was a bill that did pass this year that kind of clarified some loopholes and issues that made it difficult for both tenants and landlords to practically use reports like this. So when we say portable tenant screening report, basically this was suggested originally as a way to, okay, if I'm applying for apartments and I have applied in one place and they ran a background check, and for whatever reason I didn't move forward and live in that apartment and I've continued to apply for other places, I should not have to pay a different fee and get a new report at every single property that I'm applying to. I should be able to get that report and be able to reuse it, to recycle it with the next place that I'm applying to. Um, and so one of the one of the issues was that it was difficult just based on some of how some of these companies worked for tenants to actually provide the reports to landlords directly. Um, or landlords were adding additional requirements for tenants. And so this law clarified that the tenants could provide those directly. Another thing that it did was resolve a discrepancy between this and another section of the law that said, and it was 2023, I think, that both of these laws came into effect, and one protected tenants with housing subsidies from having to include credit histories or credit scores on their applications. Whereas this one, explicitly required that that was a piece of this tenant screening report. And so there was some confusion around that since from 2023 until 2025. And this clarified that if somebody is applying with a voucher, they do not need to have that information included on that report because a landlord cannot consider it anyway. And that's the Rental Application Fairness Act is that other piece of the law that I was referring to. And so this piece will go into effect in a couple weeks on January 1st. But like I said, the portable tenant screening reports already exist, and there's nothing stopping landlords from allowing tenants to provide these already. I'm frankly very interested in how this is playing out on the ground. I have seen anecdotally issues with tenants being able to make this practically useful. I'm curious to know if you all have had similar experiences.
We have a question in the chat, and it's a great question that I'm not sure we're going to have a satisfying answer before. But Beth said, we've had participants ask us how to get a portable tenant screening report. Do you have suggestions on getting that now, particularly now that they can make it available directly to a landlord? Great question. Becca, do you want to take this one?
I really don't have a good answer to this at this time. I suspect there are experts in our audience who actually might have more experience than Jordan and I. Jordan and I often see these issues as mostly eviction defense attorneys kind of way later on the back end. And so people who are involved in more uh, housing navigation, housing specialists roles might have more on the ground experience. So please feel free to jump into the chat or the Q&A uh, and share things that you have thoughts about. But Jordan, please add any more guidance that you.
Yeah, I think it's an area that it's relatively new how prolific it has become. This is great. Thank you, Ali. Lease Runner and TransUnion both have portable tenant screening services. Thank you for that. And yeah, it's one of those where we don't have enough time hasn't passed for us to perhaps evaluate which of these companies are good companies or not, because as you can imagine, there are a lot of companies in this area that particularly with the positive tenant rent reporting softwares and things like that it becomes a bit tricky to know what companies to trust. So I think having that is excellent. Thank you. Okay, we have another question. Landlords are charging admin fees separate from the application fee due at time of application that are not holding fees and do not roll over into a deposit if accepted more regularly again. They stopped for a little while after the after the Rental Application Fairness Act went into effect. To what extent does this or related laws cover fees like barring applications?
I read this as a question squarely about the Rental Application Fairness Act. And one piece of that is that the landlord can only charge their actual costs as application fees. It sounds like maybe something changed around this practice recently, based on this person's question. Um, I have seen also landlords use sort of like administrative costs, and they will say that, the cost of writing out the lease or something, um, it justifies that. I have seen that in the past. I don't know if that is trending towards more likely or if it's related to these tenant screening reports that is happening. But also want to know more about that. And Jordan, if you have other thoughts.
Yeah, just what Becca said. If they're charging fees more than their actual costs, that would not comply with the Rental Application Fairness Act as its previous rendition, or its existing rendition, I should say. Um, the other thing is there are limits on what a landlord can charge if a tenant is using a portable tenant screening report that complies with the law. They also cannot charge an application fee. So if this is something that you're seeing a pattern of, I would say, if, to the extent you can make note of it, like if there's one landlord in particular that you're seeing do this over and over again or things like that, it would be a really good thing to reach out to the Attorney General's office about. And you can also pass that information along to us as well. I can't guarantee that we'd have the capacity to take on an issue like that, but it's something, as we're working on this type of legislation, it's definitely something we want to be aware of. So thank you.
And I also see that someone shared a useful website for portable tenant screening reports in the chat. I will definitely be looking at that myself. It's not one I'm familiar with, but potentially a good resource for other folks on this call to use. And it looks like that's tenantbackgroundsearch.com with some other stuff after it that I will not read out loud.
Okay. There some of these questions are maybe getting into some of the fees legislation as well. So if we have more questions that come up as we go on, please put them in the chat. Um, oh, well, here we are. So the next piece of legislation that was passed this year was House Bill 1090, which includes protections against deceptive pricing practices. And this is often referred to as the junk fees bill, and this does go into effect on January 1st. Um, the goal of this bill was to enhance pricing transparency, and it prohibits certain fees. I think there were a lot of modifications. It probably doesn't prohibit all of the fees that it was originally introduced to prohibit, but on the next slide, we'll go through those fees that it does prohibit. And importantly, landlords are required to clearly disclose the total cost of the rental property, including any mandatory fees in their advertisements and listings to ensure that tenants are fully informed of the total financial commitment before signing the lease. So I think that perhaps was a, a catch-all, right, to the extent we weren't able to prevent all fees, but at least tenants will be more knowledgeable of what they're agreeing to. So this is a list of the fees that the law specifically prohibits. So related to utilities, they can only bill for the actual cost of the utility up to a 2% markup for any service fee incurred by the utility company or a third party that might be calculating those utility bills on behalf of the landlord. They can't charge any fees that increase by more than 2% for leases 1 year long or shorter. They can't charge any fees related to payment of the landlord's property taxes. Um, any fees relating to processing of rent or other payments if there's no free alternative readily available. So we see this a lot with rental portals that require when a landlord requires you to pay online and provides no free alternative and it charges you a fee. They're not allowed to charge that fee if there's not a free alternative. Um, they're not allowed to charge late charges, late payment, late fees for charges other than rent, which I think some of these might be clarifying existing understandings of the law. But so you can't charge a late fee on a late utility payment or a late fee on a late fee, it's anything like that. Um, you can't charge, the landlord cannot charge a cost that is related to the landlord complying with their legal obligation, including requirements under the warranty of habitability. So this will be interesting as we frequently see charges for like pest control, which is something that I imagine, will require litigation to clarify that that is in fact the landlord's requirement under the warranty of habitability. So stay tuned on that. Any fee that includes a markup of more than 2% or $10. So similar to the utility fee that I was talking about, this is like where the landlord uses a third party, right, to collect any sort of fees. They can't mark up the actual cost of whatever they're charging for purposes of reimbursing that third party by more than 2% or $10. They cannot charge fees related to common area maintenance. They cannot charge fees for a good or service not actually provided. And they cannot charge any fees that were not disclosed in compliance with the prior page. I believe the markup is 2% or $10, whichever is higher. I would have to double check the language, but that's typically what we see. Uh, unless you know for sure, Becca.
Um, I'm a little confused about the question.
Sorry, it says,
Is
is the
it
markup, is the prohibition on a markup charge of more than 2% or $10, whichever is greater?
um
So similarly to how the late fees are not allowed to be 5% of your rent or 50, they can only be 5% of your rent or $50, whichever is greater. The markup charge can be 2% of your rent or $10, whichever is greater, I believe.
great on that fee, right? So it would be what the landlord is collecting above the cost. I think that's what markup means in that context,
Yes,
right?
yes, yes.
Yeah.
So say you have a $60 utility bill and they charge a 2% markup cost, that would be $12. No, that would not be $12. That would be 120. um, so in this context, you can't charge more than 2% for utilities specifically, but for other types of fees, yes, I think that they would be able to charge the $10 to the extent it is greater.
Um, in contrast with 1168 that Jordan and I have already been working with a lot, this law does not go into effect for a couple more weeks. So we are still learning about it and preparing to use this more in our work. And so we may share some of your questions about this bill as well.
I have seen, just I will share anecdotally, I've seen tenants this year that have already received notices from their landlord saying, don't worry, there was this change in the law, but your rent bill is not going to change at all. We basically they're just moving things around. So it provides sort of like a table that has on the left side your prior fees listed out, and on the right side your new fees. And it just removed all of the ones that are listed in this. But then at the bottom says your total amount due is still X. So to Becca's point, it'll be really interesting to see how this bill plays out in practice. and something that I think we would love to hear from you all on as you're seeing it as well.
I'll just add a little more context about the policy position that we've taken, which is, the opposition to this bill said, this is going to result in higher rents. I think our position is even if that is the case, it should reduce some of the volatility and unexpected fees that, like, even if they do what Jordan said and they include everything as rent, to me, that is more protection for tenants who are often in the position of budgeting around what they know their rent bill would be. And when a $300 additional utility and fee bill hits their ledger, that often lands them in our eviction clinic.
Yes,
We have another question that landed in the chat, and I do encourage you to try to use the Q&A for questions generally, but this is okay because I see it here. That it's how does this affect leases that are currently in effect? Are landlords required to drop those prohibited fees? Jordan, do you want to answer?
my understanding is that it's any lease that is executed after January 1st of 2026. So to the extent that a lease expires in 2026 and it's renewed, that new lease would have to um, incorporate these changes, correct? And so again, apologies that we're still figuring this out, but the new lease would have to incorporate them. So it's essentially like the old leases will be phased out, but they don't those requirements to pay those fees doesn't automatically drop off on January 1st.
Though some pieces of it might we might have an argument that they're retroactive. Like, for example, if the landlord is collecting on a fee that was prohibited but not I, all that I believe some of the language in this bill may be ripe for some lawsuits and court interpretation. And so there may be some arguments available that some of these fees, even if it's a pre-existing lease, may be unlawful.
With most things in the law, the answer is it depends. So yeah, I think practically speaking, it a lot of that will come down to whether or not people are willing to challenge it in court to get that sort of clarity. And as the leases are phased out and new leases are phased in, I think it'll get a little bit more clear. Usually the first couple months of this kind of legislation can be a bit of a black box. Okay. Seeing no other questions. Continuing on. So under this new law, there are explicit remedies for tenants when the landlord has violated this provision, this new law. So in addition to other remedies, a tenant may send a written demand requesting on behalf of themselves or a group a reimbursement of any charges collected in violation of this section, along with any actual damages, similar to what we currently have for the late fees statute. This demand may also request the landlord to cease collecting these improper fees and include a notice that any future improper fees will not be paid. And if the landlord does not comply within 14 days, they are liable for the actual cost of the fees plus an 18% interest rate. And this law allows for the Attorney General to enforce this. So again, the Attorney General's office works based on a complaint system, and it's really what landlords they may or may not target is based on the volume of complaints against that specific landlord. So again, if you guys are well primed to see if a landlord is engaging in this type of conduct repeatedly, that might make it ripe for you to contact the Attorney General's office. or our office, and we can also, evaluate and collect that information to pass along to them as well.
Any other questions about that junk fees bill before we move on to the security deposit protections? Great. Some of it we will learn together as a couple weeks pass and we move into 2026. Another one that goes into effect with this new year is some clarifications around security deposit protections. Um, and so uh, these protections were largely already in place, but there were some parts of the statute that weren't very precise, and that led to a lot of litigation. Um, and so clarifying some of these terms and strengthening some of this language will hopefully make it easier for security deposits to be calculated and returned, and avoid some of those extra need for small claims cases, which often the tenant who is owed a security deposit doesn't, it's not worth it for them to raise those claims. And so having these terms be clearer helps streamline that process. People get the security deposit or not, and they hopefully will result in less litigation. Um, so the term normal wear and tear, um, it it was modified by this. It will be modified by this bill. So some of the damage and uncleanliness that can be caused when a property was reasonably and typically used is now included in normal wear and tear. Um, and so one other option that it provides either landlords or tenants is a right to having a walk-through inspection after the furniture is moved out of the unit, but before the tenant has returned possession. And that will hopefully give everybody a little more clarity around, oh, okay, these are the kinds of things that we might charge for. Or alternatively, you could, finish scrubbing the blinds or whatever it is to avoid incurring a charge on your security deposit. It also expands the recourse for tenants who want to seek compensation for the wrongful withholding of a security deposit. So for the next couple weeks and previously, it has had to be both willful and wrongful. And those are both legal terms that have a lot of context. I won't get into those weeds here, but all that to say, the willful standard is going away from whether a landlord has wrongfully withheld the security deposit. If it's wrongful, it's it's unlawful, period. Um, and so that will hopefully add some clarity and again take away some of those ambiguities about like the tenant doesn't need to know the landlord's intention or read their mind in order to know that it was wrong. It also allows tenants to request documents related to that security withholding, and clarifies some of the logistics of how those payments should be refunded. And like I said, goes into effect in a couple weeks. We shall see how that one plays out as well. Questions about security deposits?
And if you're thinking, wow, reasonably and typically seems as ambiguous as normal wear and tear, you're not alone. So we will see again how the courts choose to interpret those terms. Okay. Oh, we have a question. So if a lease specifies painting after the tenant moves out and a cost, can that still be charged if a tenant has signed it? Recently, a landlord wouldn't remove this from the lease upon request and said this applied regardless of paint damage. It's a good question. Um, I honestly would have to take a closer look at this bill to see what the language is around the um, which parts of it can be waived by an agreement of that effect. And also, I know that there was a lot that was introduced to try to offer clarity that was rejected by the legislature. And so, to the extent, what you're articulating is something that was originally introduced but was not formally adopted as the final bill, there might be an argument for the landlord that had the legislature intended to prohibit that practice, they would have included that. Um, so that I would have to take a closer look. What do you think, Becca?
I agree with you, Jordan. It might be a little bit up for interpretation. But I think there is an argument that if again there is not any damage to the paint if somebody has not caused an unusual amount of damage to that wall, then there's no way to avoid that being charged from the security deposit, and that would be unlawful just based on I would have argued that before this bill, frankly, about the security deposit. Um, so again, I don't want to get too much into the weeds. That might be one that's worth having an attorney look into in more detail.
Okay. Um, Seeing no other questions right now. If more come up, we can certainly answer them. House Bill 1108. This prohibits it, it includes prohibitions in rental agreements due to death. So it's intended to protect families from the financial burdens associated with residential leases after a tenant's death. So basically, when a tenant, you're probably familiar with this, if a tenant unlawfully terminates their lease early before the end of the lease term, they may be liable for an early lease termination fee. Plus, they could be responsible for the rent for the remainder of the lease term, less the landlord's obligation to mitigate their damages. And so historically, there have been lease agreements that include clauses that if a tenant passes away, that is effectively the same thing as an early lease termination, and the tenant's estate is therefore then liable for those same fees as if they had, if the tenant did not pass away but just surrendered possession of the property. So this law works to protect those estates of those deceased family members and says that the following lease clauses would be unenforceable. So any requirement of the deceased estate to pay liquidated damages, to accelerate the rent beyond the end of the month or more than 10 business days after the death, um, to require forfeiture of move-in discounts, or to impose any other fee or damage or penalty related to early termination resulting from a tenant's death. I think perhaps there was a case in the news about this that got that got a lot of attention, where a tenant's estate had to deal with this, which perhaps prompted this bill because we had some individuals contact our organization in response to that news coverage, concerned about that as well. So, yeah, any questions about that? Uh, So protection around how long the family has to recover items. That is a great question. I think, well, one to the extent that if a tenant, my understanding in the response that I've given to tenants with this question is that that if the tenant passes away, say in December 5th, but they've already paid their December rent, the family is the tenant is entitled to possession of the property through the end of December at the least, right? Because they've paid the full December rent. Um, to the extent that the family wants continued access to it, I think that they can have such access, but they may be just responsible for the rent for the continued time that they are holding possession of the property, if that makes sense. But I don't think it specifies how long they have.
Yeah, I think that's right, and I would have to go back to look at the bill specifically. I do believe that it said something about if substantially all of the property has been removed and 30 days has passed since the person's death, then the landlord can take possession back of the unit, but I'm not exactly sure about the timeline for the reverse of that. Again, this is not an issue that we deal with a lot, but certainly worth digging into this bill and reading that more specifically if you are in that situation or have a client in that situation.
Ah, well, I think we this next slide might answer your question. So the landlord may take possession of the unit without filing an eviction if the tenant's personal representative notifies the landlord of surrender in 30 days have passed since the tenant's death and rent remains unpaid or substantially all of the tenant's property has been removed. So I think to the extent that the estate is still paying the rent, they are entitled to access to the property to collect their damages. If the tenant's death results in damage to the property, the landlord is permitted to retain a security deposit or associated damages sufficient to cover the costs related to the damage caused by the death. And this provision went into effect on September 1st. So I hope that provides a little bit more clarity.
Okay, the next bill we can chat about. And again, feel free to drop questions. We might not be able to field, frankly, all the questions about that last one because we are just not as in that space. But this SB 25 020, landlord, tenant and landlord law enforcement, expands the Colorado Attorney General's authority to enforce landlord-tenant laws. It also expands local government's authority to enforce landlord-tenant laws. Both of these things, again, I'll speak from our experience as tenant advocates ourselves. There are not enough of us. There is not enough. There are not enough lawyers who take these cases on behalf of tenants to raise private actions for all of the bad landlord behavior that exists in Colorado. There are certainly not enough of us who do it without charging for the tenants to get those remedies. And so having the Attorney General and local governments have some role that is supported by the law, where they can investigate claims on behalf of tenants, really helps everyone, I believe. Um, and so it also establishes a receivership mechanism for multifamily residential property. And now I know there were some big news stories in 2024 about buildings that were taken under receiverships. And I think that the legislature noted that those things weren't always done in a way that protected tenants' rights. So this law beefed up that process, made some clarity around what a receivership entails, and um, allowing for that receiver to operate the residential property when there's a pattern of neglect. So, probably an example of this that you all likely heard about were some of these apartments in Aurora last year, where there was really a lot of negligent in terms of the negligence with the habitability issues on the part of the landlord, and potentially blame of certain gang affiliated people. And I won't get into that debate, but I will say that it was clear the landlord was not fulfilling all of their obligations under the law, and somebody had to step in. So hopefully this law will allow tenants in those buildings, those situations where there's truly negligence, to have some other authority step in. So this was all generally effective on August 6th, though I think there's some delay to the Attorney General and local enforcement. Jordan, do you know if that is all in effect now?
I'm not sure what the delay is
Okay.
referring.
And I can look into that if people have specific follow-ups about what's possible. But generally, if you are able to take action, you're probably the Colorado Attorney General or a local government official who is interested in enforcing those laws. We encourage you to do so if you're in that position. And probably you'll be able to soon if you can't already. But obviously that will also depend on things like funding for those activities. Questions about that?
Okay, hearing none. Lastly, for our past items, the budget item of the Eviction Legal Defense Fund. So this was a fund that was established in 2019 and provides funding to nonprofit organizations that offer free legal assistance to tenants facing eviction. Full disclosure, like yours truly, the Colorado Poverty Law Project. The formal 5-year evaluation of the ELDF was published in December of last year and demonstrated the program's significant progress in addressing housing instability and improving access to legal representation for low-income tenants. There was concern that this would be eliminated based on the budget challenges, but thanks to advocacy in the community and support from the Joint Budget Committee, it was funded at the same amount of $1.1 million as it was in years prior.
Okay, so now we're going to move into the section where we talk about the things that did not actually make their way all the way through the legislative process. So again, everything that we said up until now is the law or is going to be the law in a couple weeks. But here we have the laws that advocates on either side tried to raise, um, and that these did not make it. So these are not actually the law. Um, but it's interesting to dive into what happened and what that debate looked like a little bit. So we'll touch on these two. So this HB 25-1235 was regarding jury trials for tenant proceedings. And just as a little bit of background, it's our position that this already is a right that tenants should be able to exercise. Certainly under some circumstances. And there was a case that got to the Colorado Supreme Court, and the Colorado Supreme Court did hold that tenants have rights to a jury trial under certain circumstances, but then that decision was reversed. Was the Colorado Supreme Court uh, withdrew their own opinion because they learned some new facts regarding to that specific case that made some of the things that they had held not true. And so we're kind of in this weird position where some courts are not allowing jury trials. Still, in fact, I would say many Colorado courts are not allowing tenants to access these jury trials. Um, and until we find the next perfect tenant who is in the position to raise that claim back to the Colorado Supreme Court, there is some tension in that process that the legislature had an opportunity to help clarify and resolve in this past cycle. So it would have codified that right to the jury trial. It would have also provided tenants with more personal service, more likely personal service with 3 attempts to serve the notice, and more time to prepare for those trials. It would have repealed a law that allowed lease agreements to waive those jury trials. Um, it did make it through the Colorado House, but it did not make it through the Colorado Senate. Um, if you're a person who's interested in jury trials, we could talk more about that. But for the purposes of today, it did not pass, so we probably don't need to dwell on it very long.
All right. So similarly, House Bill 251092 was introduced that would speak to rent increases by landlords to tenants. So under the current law, the for cause bill that was passed in the previous legislative cycle that provided certain protections for tenants against evictions with or terminations of leases or non-renewals of leases without a justifiable reason. The legislature required that landlords, particularly for residential tenancies that are more than 12 months, with some exceptions, the landlord cannot initiate an eviction without cause. And cause includes, certain at fault reasons where the tenant, may have breached their lease or something else. But also includes no fault basis for evictions, like if the landlord is selling the property or wants to move in. One of those no fault bases for evictions is if the tenant refuses to sign a new rental agreement with reasonable terms. And we've seen throughout this last year that what reasonable terms is not clear. And so this bill would have sought to clarify that term and specified that a rent increase in a new rental agreement is considered reasonable and not retaliatory or discriminatory or unconscionable if it aligns with the quote fair market rent, as evidenced by the rental amounts of comparable properties. And comparable properties was also not defined. So that this bill was defeated in the Colorado House. And there's the debate among rent caps and rent increases, how to regulate rent increases, persists. So, any questions about that law? Or I should say that proposed bill that failed. It's not a law.
Yeah, if it wasn't clear, this was a proposal that was put forth by primarily landlord and realtor groups trying to align that fair market rent as reasonable. And CPLP was also opposed to their position, though I can say from my perspective, and I think CPLP's perspective, like we would actually love a little more clarity around what is reasonable, but I think reasonable also has to factor in certain other criteria and thought about what kind of property it is and the length of a tenancy, other things like that that are that might not allow for a landlord to call bumping something up to fair market rent reasonable. But again, that is only my position. I'm not speaking on behalf of anybody else there. Another bill that also failed was also this was one that was largely landlords and realtors were proponents of. There have been a couple of bills passed over the last several years that the landlords believe have increased their costs. Um, and one of those was the SB 24094, which put a lot of teeth that did not previously exist into the warranty of habitability, gave tenants uh, some remedies and clarified some of the landlord's responsibilities. Uh, the landlord, the landlords and their lobbyists do not like that this would raise costs for the landlords. And so they tried to repeal it. Also, House Bill 231120. This gives tenants who receive SSI, SSDI, or Colorado Works, otherwise known as TANF or TANF, benefits, the right to a mediation in between when they receive a demand and when a landlord can file an eviction case. Um, Again, this is a law that, in our view, is a pretty small percentage of eviction cases where people are actually exercising that right. And so we have some doubt about whether it's actually, increasing the cost of housing across the board, or rather than essentially just giving some other protections to these vulnerable populations who have already been identified as needing extra government support. So anyway, they tried to repeal these two laws and they failed. It was defeated in the Colorado Senate where it started. I again not hiding the ball here. We are tenant advocates and we were supporters of both of these bills, and so it was good news in our advocacy work that this did not pass. But open to questions about that or the underlying context of either of those bills too.
Okay. Moving on to what is perhaps one of the hottest topics right now across the country in landlord-tenant sphere. So House Bill 251004 would have prohibited pricing coordination between landlords. So um, if you work in this field, you're probably familiar with some of these companies like Real Pages that use these algorithmic devices to price fix uh, rental rents and things like that across the country. This would have prohibited the sale or use of these devices in Colorado that set or recommend rental prices or occupancy terms based on data for multiple landlords. And this is data that's not publicly available, right? That's what makes it price fixing. So Yeah, it would have only applied to non-public information. It also would have specifically prohibited the use of an algorithmic rent setting device if part of a scheme to fix rent prices. This bill was passed by the legislature, but was vetoed by Governor Polis. Interestingly, so we would have been CPLP was in favor of this bill. Interestingly, the Colorado Attorney General's office, in conjunction with some other states and the FTC, has in the past several years has sued some of these big landlords and these rent price fixing companies like Greystar and Real Pages. And recently, the Colorado Attorney General's office just secured a pretty sizable settlement agreement with Greystar, and so did the FTC, in which the multiple states will receive, you know, there's a collective amount of like $25 million that will be distributed among several states, including Colorado. Um, and I think there will be some agreements as part of that. We don't have the details just yet because it hasn't been approved by the court, but there will include agreements that sort of regulate the behavior of these companies to include this this non-public information. So that is maybe the silver lining in this bill not being passed. Another wrinkle is that just this week, President Trump signed an executive order that actually limits it prohibits states from passing legislation that regulates AI. So arguably, that executive order would have preempted this type of legislation. So that is to say that it'll be really, really interesting to see how all of this plays out. How that executive order impacts some of these lawsuits and some of these other states trying to regulate this. So I'm like, you can tell I'm really interested and passionate about it, but I don't think this will be the last you see of this conversation. So I can try to answer any questions. A lot of it is way above my pay grade, but we can, if you have questions, I'm happy to try to answer. Okay, well that brings us to the end of uh, our formal content. So we can just open it up now to any questions that you may have. I know we've got a lot of time left. So whatever questions folks have, feel free to drop them in the Q&A.
I have a question. Oops, sorry. I have a question while we're waiting for other questions to come in. So, as the Colorado Division of Housing, we tend to get a lot of questions from the public, particularly tenants, about um, warranty of habitability issues, um, legislation that's passed that they believe their landlord's violating. We get a lot of those questions, expecting that we, as you know, understandably, the Colorado Division of Housing should have all these answers. We certainly don't. Is it okay? I mean, we send like a generic list of for questions about this, Colorado Legal Services, for questions about that, Colorado Housing Connects. Is Colorado Poverty Law Project an appropriate resource to send somebody if they have questions about tenant landlord legislation, or just to include you in our response that we provide?
Certainly, yes. I'll also shout out the Community Economic Defense Project, and I know we have some folks from there on this call too. They have a legal arm as well as other services, rental assistance, other kinds of services for tenants, and they are also experts on warranty of habitability issues.
Awesome. Yes, and one of our voucher partners. So perfect. Great. Thank you. Expect some calls, I think, once we put that out there.
Yeah, I should say if you have specific issues with clients, the best way is to fill out the intake form on our website. And there is a place to indicate that you're a service provider asking a question on behalf of a client, or you can ask your clients to fill out that intake directly. And I should say we do not have the capacity to take to help everybody who needs our help, and I wish we did. But especially when it comes to discrete questions that might help you as service providers answer client questions, certainly happy to field those via email.
I will
Thank you.
also say for habitability resources, in some jurisdictions, it's a good idea to refer folks to their local municipalities. So particularly Denver has done a lot of work in the last year to improve their procedures in their Department of Health, Public Health and Environment, and so they have online complaint forums. Where a tenant, if they believe their landlord is violating the warranty of habitability and they feel comfortable doing so, they can submit a complaint and have a city inspector come out. And that, I will say, if they have taken that step, I think, and then they come to us, we may be more inclined to help them at that stage, because there is this, right, there's this initiative, there's this documentation, all things that we uh, as lawyers sort of need to be able to investigate a case.
Very helpful. Thank you.
And a couple of people have asked if we could share the PowerPoint presentation. I'm happy to share that if you, Kate, can distribute it to the folks who attended.
I sure can. We'll do a follow-up um, with a link to the recording as well, that we'll share. So, well, wonderful. Well, folks don't have other questions. We're happy to give you all a little time back. You don't have to tell anyone. You can say you're still in the webinar. Thank you so much, Becca and Jordan. This is, as always, is an awesome presentation that answers a lot of questions, especially in the last several years with so much housing legislation, which we're thrilled about. But it feels like a lot, more than we've ever had. So it's hard to keep it all straight. This is super helpful. All
Thank you
right.
so much for having us and for all the smart questions.
And I'll put, I know we just had our email on the slide. I'm gonna put my email in the chat. And if there were questions that were asked that, Becca and I know there were a couple that we said we can maybe take a closer look at the bill. If you're like, we're really not satisfied with our answer, please, I know there was a few, so they may be escaping me. Please email me and I will actually look at the bill and get you a better answer. To the best of my ability.
Thank you. Appreciate that resource. All right. Well, everyone, thank you again. We'll see you next month for our monthly webinar. I hope everyone has an amazing holiday season and a happy new year. Thank you.
Thank you.
Thank you.